Thank you, Tina, for that very kind introduction. I am indeed grateful for NACM's invitation to speak at this conference today. It is a real honor for me to have this opportunity to show my appreciation for you, the people who, in a real sense, are the face of the judicial system for many, a juror, witness, plaintiff, and defendant. And people who, as a result, are absolutely essential to the smooth functioning, the reputation, and the integrity of the judicial system. You grasp that your demeanor in courthouses and behind the scenes can determine how citizens relate to the judicial system, whether they can put their trust in the system and count on getting a fair shake, whether the system looks at them as a human being with dignity or just another number in a never-ending series, whether the oath they swear has meaning, obligation, and weight, or is just a rote recitation, and whether this system that can determine the rest of their lives is competent, committed, focused, and fair. More importantly, I truly appreciate the opportunity to address your particular membership today because I believe that you, as court managers, are in a unique position to offer insight and support for the project in which President Brown and I have been involved for the past year or so. The Community Engagement in State Court Project seeks to restore public trust and confidence in state courts, particularly among minority and economically disadvantaged communities. Before I begin, however, I would be remiss not to take a moment to address the recent killings in Dallas, St. Paul, and Baton Rouge. For 3 consecutive days last week, we were shocked to our souls by tragic events that have everything to do with the challenges before us here today. The fear and mistrust in our criminal justice system on all sides. The facts are still coming in on each of these incidents, but it's not too early to mourn and honor all of the victims. The 12 brave law enforcement officers killed or wounded in the line of duty in Dallas, and the victims of police killings in Louisiana and Minnesota. Each of these tragedies springs from a daunting set of long-standing causes and a building crisis of fear, hatred, and distrust that shorten all of our triggers, times, and bring panic and irrationality to what should be routine events. This is a tough time to talk about these issues, but talk we must if we have any hope of stemming the rising storm of violence we saw last week. So to return to my planned discussion, last fall, I was honored to be among 16 people from around the country appointed to the National Advisory Board on Community Engagement in State Courts. The board is under the auspices of the National Center for State Courts, part of its Conference of Chief Justices, and the National Consortium for Racial and Ethnic Fairness. We have been meeting regularly to identify the gap in trust and confidence in the courts between minorities and white non-Hispanics. It is an urgent mandate. A recent survey by the National Center for State Courts found that only 32% of African Americans believe that the state courts provide equal justice to all. As court managers, I know that you encounter this trust gap every day. This is shocking when you consider that historically, the courts are where minorities have turned for justice, starting with the hundreds of successful freedom suits by slaves before the Civil War, and continuing with Brown versus Board of Education. We shot down the separate but equal doctrine. Shelley versus Kramer, which ended restrictive covenants that led to segregated housing. Even last month's Supreme Court's decision in Fisher 2, which upheld affirmative action in college admissions. Our board started with a listening session in Baltimore, and then kicked it up a notch with the first of our televised sessions called Courting Justice, featuring Tavis Smiley, recorded just last month in Los Angeles, California. Let me walk you briefly through a few of the topics we have been compelled to address in these sessions. Fees and fines as barriers to reentry or full integration for those caught up in the legal system. Procedural barriers to assessing justice, such as a lack of legal representation for both civil and criminal matters, or the cost of filing appeals and motions. Community engagement initiatives to build trust between the courts, law enforcement, and the community. In America, citizens must feel that the courts are theirs. Reform in our bail bonds and other criminal justice systems that discriminate against the poor. Sentencing reform, the criminalization of mental illness. Judicial diversity in both elected and appointed bench positions. Expungement of criminal records and support for ban-the-box efforts that facilitate hiring of those who have paid the price for their crimes. Reforms that achieve payment of child support owed to state without criminalization. Zero tolerance laws that have turned the school to prison pipeline into a gusher. In light of these public concerns, it's impossible to avoid addressing two overlying issues. First, the pervasive implicit bias throughout our society. And second, the great perversion of our American justice system, now known as mass incarceration. It started with concepts such as zero tolerance and 3 strikes, you're out. But we've tried mass incarceration for decades now, and it's simply not working. I'm sure this audience is familiar with the statistics. The United States of America tops in imprisonment in the history of the world. We have just 5% of the world's population, but 25% of the world's prisoners. We have more people in prison than does the communist dictatorship China, which has more than 3 times our population. It's no surprise that our prison population is disproportionately poor and minority. And it costs taxpayers more than $100,000 per person to lock them up. If mass incarceration worked, we've been seeing some positive results. Yet, most urban cities have been experiencing crime waves several years long. The good news is that the effort to reverse mass incarceration is starting to get bipartisan support across our nation. Politicians on the left and on the right are coming to realize that we're wasting far too much money locking up our citizens while not getting desired results. The most talked about solutions to reverse mass incarceration are closely aligned with our mandates to restore trust among minority communities in the criminal justice system. we've heard from many segments of the community, and they suggest that we should devote more resources to court-supervised drug treatment programs for nonviolent felons, and supervised probation that includes job skills and family values. In other words, make probation a program for personal healing, not just a time period for avoiding new arrest. Develop similar reentry programs for paroled felons, working with neighbors and family members as well, to facilitate rehabilitation and reconciliation. Ban the box on job applications that requires you to check it if you've been convicted of a felony. And make the judiciary, the police, and probation and parole officials more representatives of the communities they serve, and demand more minority judges and police officers at every rank. I suspect that their call for more minority judges and police officers is not advocating a similar position of a certain presidential candidate who complained that he could not get justice because the judge in his civil case came from another culture. What they're saying is that we can start to build trust and respect all over the American population when the justice system reflects our rich diversity and multiculturalism. Mass incarceration and loss of faith in the justice system among minorities, however, can be seen as mere symptoms of an underlying disease. It's a highly contagious disease, and one that any among us might be carrying right now without even realizing it. I'm turning now to implicit bias. Overt racism is easy to spot. Implicit bias hides in our schools, our workplaces, our jails, and in our courts. It's in your court right now. It will probably always exist at some level in one's individual and collective consciousness. But we definitely have the ability to control the extent to which it results in injustice. And it's just the beginning. The potential for reform is limitless. It is time to expand our horizons and explore further innovative alternatives to incarceration. And I believe that we can do it for far less than the $100,000 it costs to lock up that same person every year. While judges like me are constrained by Constitution, statute, rules, and codes from speaking out and against certain actions and laws, we too are dismayed and disappointed, like many in the general public, when citizens are treated unequally. And because of unequal treatment, there has been an erosion of trust between the courts and the communities we serve, especially communities of color. Our multi-city town hall series will allow us to hear and listen to new perspectives on how courts can better deliver justice for all. And at the conclusion of the listening tours, the advisory board aims to develop effective tools and resources that will assist state court leaders in engaging marginalized and disenfranchised communities to ensure equal access and equal justice to all, and to improve the trust and confidence those communities have in state courts. Imagine, if you will, justice for all. You have an incredible opportunity to help us develop solutions by engaging with us here today or by sending your thoughts to the National Center of State Courts in care of Constantina Vigenis. I want you to take a look at the screens for a short clip of the Tavis Smiley Show, Courting Justice, our first of 5 to 7 television shows. Before we start, however, I would like to give credit to the State Justice Institute for funding Courting Justice, and of course, to Jonathan and those folk at the State Justice Institute for supporting our advisory report. At this time, would you take a look at the screens?
Our court system is designed to be fair and impartial, but these days, many in the country see the judicial process as biased. What can be done then about this erosion of trust is the subject of this town hall meeting, and our audience are stakeholders from various communities and organizations. And our panel tonight, 5 distinguished jurors: California Supreme Court Chief Justice Tani Cantillo-Sakaui, Judge Jimmy Edwards from the 22nd Judicial District, City of St. Louis, Associate Justice Maria P. Rivera from California's 1st District Court of Appeal, Judge Daniel J. Buckley, Superior Court of Los Angeles County, and Chief Judge Eric T. Washington, District of Columbia Court of Appeals. But tell me why judges are willing to take off the robes, come off the bench, and engage in a conversation with the people you serve.
Well, I think the short answer is that judges' stock in trade is the public's trust and confidence that we will protect rights and liberties and that will resolve disputes fairly. And yet, what we were seeing around the country in light of what had happened in Ferguson and the law enforcement involvement in Baltimore and around the country was an erosion of that trust and confidence beyond what it had been before. And we understood that people, the community at large, was very interested and very confused about the role courts play.
Bias. Is the court biased?
I don't believe the court as an institution is biased.
Okay.
No one sitting on the bench is going to admit, oh, I have racial bias, I have gender bias, I'm biased against immigrants. They're never going to admit that, and they don't believe it. Genuinely, they don't believe they are biased. What they don't understand is that in the last 10 years or 15 years has been the neuroscience developed of implicit bias, the understanding that we were all ingrained, even people of color ingrained with biases in favor of the majority community, the dominant culture. And learning about that is something that I think would very much increase the trust and confidence of the people in the courts.
What damage does that do to how we view the judiciary when people who are running for president, who are the presumptive nominees of their party, come after judges in that way?
And what it means is it gives us an opportunity to explain that we are not judges in black robes. We are not politicians. We are, in fact, honest brokers of the law. We toil in dark courtrooms. We write out our decisions so that if you think something fishy is going on, you can read about that we relied on past cases and we relied on the law and we interpreted it.
Put a list out there of other issues that we need to consider when it comes to the lack of trust that the public has in our court system.
My 5-year-old son was killed by a policeman, and I used drugs to medicate the pain. I cycled in and out of prison for the next 15 years. There were times when I was in possession of a drug. There were times when I was not in possession of a drug. When I wanted to go to trial, my public defender came to me and said I would get 10 years if I lost, and because I had a prior, he advised against me even going to trial. Realization I deal with is that this system is not designed or equipped to give people a fair trial.
Judge Buckley, you made a point saying how much of what Susan's talking about has to do with the meager resources that we give to public defenders?
I think there's so many answers to that question. Resources, yes. There is always going to be restrictions on the ability to investigate and so forth. we all have to go through the lenses of our personal experience. And Susan, I definitely hear what you've experienced. What I saw in the courtrooms when I was a felony judge is individual public defenders working extremely hard for their clients, trying, and I think I saw many times, giving advice as to what is the potential jury verdict and what would be the potential punishment, and their advice as to what they should or should not do.
Services.
Well, I think legal services with respect to the African American communities and our marginalized communities is at its lowest. In fact, African Americans and marginalized communities have the least amount of trust in our court system than all others. Starting with the freedom of slave suits to the not so equal Jim Crow, to Brown versus Board of Education, to now, today. How has it that the African American community, who has always relied on the court system for justice, equal protection, and due process, are now concerned? Why? Because of cases all over this country where there is an appearance of unequal treatment because of a lack of representation, adequate representation. When we compare the types of sentencings that African Americans receive compared to their white counterparts for the exact same offense. What is the root cause of all of these things? We've talked about implicit bias, but certainly there are other things like bail. I've created this phrase of sentencing while mad. When judges sentence folk and they're angry, and they tend to give longer sentences to those that are standing in front of them, and too often they're young African American men.
You were right about the fact that African Americans have had to rely on the court system more than most other communities, and I'd only add to that, it's not just relying on the court system, but if we're going to be honest about it, it is in part because of interposition and amendment and nullification that all of that came to be. It just didn't happen because we appealed to a court system, as you well know. For all that we've discussed tonight, all the challenges that the court system faces, and the challenge most principally that you have in trying to build the trust in the public in what you do, what gives you reason to be hopeful? How are you sustaining your hope?
I think that it gives us hope that we can find out what would be important to the community by engaging in these types of conversations that you're allowing us to do through this show. It's interesting. We're not just answering questions. We're actually hearing these concerns. And I think it's important for us to hear these concerns. We are taking, as judicial officers, in many ways, steps to correct what we think are the problems. And we're looking at issues like plea bargaining, as was mentioned, and we're looking at bail reform, and we're trying to be proactive in making sure that the justice system from the beginning to the end is procedurally fair and is the appearance of fairness is not lost on the general public. So we care about this. We're invested in this system. And so what gives me hope is that people are willing to come out and tell us personal stories like we just heard. And it's not something that we don't understand. It makes us think more in terms of what our obligation is as judicial officers about making sure that pleas that are people who are coming before us to plea, and we're engaging them in conversation about whether they in fact committed the crime and whether they were prepared to enter that plea, are able to answer those questions honestly, and we can then, from our perspective, decide whether to reject or accept the plea, understanding that we're not trying to get in the middle of the relationship those people have with their lawyers. So we walk a fine balance, but hearing these concerns gives us more to talk about. And I want to say the Conference of Chief Justices, who were the body along with the National Center and the State Justice Institute, pulled together this outreach effort along with the National Consortium on Racial and Ethnic Fairness in the Courts, because we're concerned, because hearing from people is what's critically important for any changes that we want to make in the future.
This is, as I said at the top, a very rare opportunity to have these conversations with these judges at this level. Please thank these judicial officers.
I am very honored that Paulette Brown, the esteemed president of the American Bar Association, is here today. She comes in a dual capacity. She is the leader of over 450,000 American judges and lawyers, as well as a member of the National Advisory Board of the Community Engagement in State Courts. Please welcome President Paulette Brown.
What time is it? What time is it? Good afternoon. Good afternoon. Thank you. And I have to tell you, I'm not trying to be cool with the dark glasses on. I changed my glasses in my car this morning, and my glasses are in my car at Newark Airport. But if I took these off, I wouldn't be able to see. So I think that you might rather have me see than not see. But I am really privileged to be here this afternoon. Thank you so much, Judge Edwards, for your presentation and for all of the work that you've been doing on the advisory board. And as I mentioned to Tina in an email last night, I look forward to doing my part once my term is over in 3 weeks and 2 days. So it's really always a pleasure for me to talk to people who are involved in the legal system, who, as Judge Edwards mentioned earlier, so intricately involved, the face that people see on a daily basis when they're coming to the court system, and a group of people who understand the current dynamics within our court system and within our justice system. And you're a group that really understands the judiciary and the fact that it is one of the most important foundations of our democracy. But we also know that the rule of law can only be maintained when the public, and all of the public, believes in the fairness and wisdom of the judiciary and our justice system. Judge Edwards talked about some statistics about how many people believe that the justice system is fair. There was a recent Harvard study that showed that without regard to race, more than 1/2 of all young people believe our justice system is not fair. So that really makes me even more happy that NACM is so committed to community engagement in the state courts and to interacting with communities of color, with economically challenged communities, to enhance trust and confidence. It is something that is so sorely needed as events, which I won't go into again, continue to evolve throughout the country. So, one of the things that we think about our Constitution, I think about Alexander Hamilton when he said, the ordinary administration of criminal and civil justice contributes more than any other circumstance to impressing upon the minds of the people affection, esteem, and reverence toward the government. So he recognized the importance of our courts, and we all know as court administrators, as lawyers, judges, and informed, concerned citizens that one of the greatest challenges facing our courts today is the perception that the justice system is unjust. And so there are many reasons for that perception, and when we consider the fact, though, that 11 states now spend more money on their prison systems than they do on education, we have to wonder why, with that sad statistic, that we are not doing better. Those of us in the legal profession and the court system also confront a reality that more than 80% of low-income people with civil troubles do not obtain the legal representation they need, and that some of these civil troubles can evolve into criminal troubles, that we have a system where we have actually gone back in some ways to a debtor's prison. So if our Constitution is to have real meaning, everyone, without regard to where they come from, must be treated fairly or perceived as being treated fairly. So I'm particularly honored to be involved in today's timely discussion about how we ensure that there's justice in our justice system for all communities that have faced oppression, discrimination, and other inequities in our society. To enhance injustice, as Judge Edwards mentioned, we have to confront implicit bias in the legal profession, and just as important, in the court system. And so I think that implicit bias, as I have come to understand it over time, plays a significant role in the injustices that occurred. So, you know, for many years we've used the image of Lady Justice with her scales in her hands and eyes covered with blindfold as a symbol of what justice ought to be, objective and even-handed. But we found that in recent years that attempting to ignore our differences does not result in impartiality. And in fact, it's important to acknowledge that we are not all the same and to admit that we have implicit biases, and yes, none of us are exempt from having them. All of us have them. I've taken several IAT tests, implicit association tests, and I know that something that my sister accused me of before there was even such a test. Unfortunately, I found out that it's kind of true. So I'll whisper it to you later what it is, but it has nothing to do with race or anything like that. It's just something that she's accused me of, and back then she would just say, "You're so prejudiced against this group of people." And so I found that I'm not really, but I do favor the other people. But now that I know that, our implicit biases don't necessarily go away. But when we acknowledge that we have them, it can affect our decision making. We can force ourselves to not allow our implicit biases to affect our decisions. So that when a person who comes to me, who is in that group that my sister accused me of, I will ask myself a series of questions about this individual and make sure that I am not relying on something deep that's within me that tells me that I should not give this person a fair shake. So, implicit bias, it really affects our understanding and our behavior without our realizing, which is why it's important to really understand and to understand that having implicit biases does not make us bad people. Thank goodness, because I don't think I'm a bad person. So we have to know that it doesn't make us bad people, but that it can have negative consequences if we don't acknowledge them. So when I became ABA president about almost a year ago, I gave a lot of thought to the best way to change some of the disturbing realities that interfere with achieving the ideal of a fair and equal system of justice. One of the first things that I did was to bring together committed and diverse individuals, a group of people to form the ABA Diversity and Inclusion 360 Commission. It included the best minds in our profession from almost every sector of the profession in solo firms, corporations, federal government, law schools, and the federal bench. And the work that I asked them to do, because there were a certain set of goals and tangibles that I wanted to have by the time my term is over at 5 p.m. on August 9th. And, their reaction is that she is crazy and we cannot get all of this done in a year. I am a little bit crazy, and I've never denied that, but I said that it can be done in a year, it will be done in a year, and they have done it in a year. And so they have created an array of policies and online tools, videos, surveys, and templates that collectively have the potential to make a major difference in the legal profession and our justice system in really practical ways. And so it's our hope that organizations like yours and entities within and outside of the ABA will use these free resources, free, to foster diversity and inclusion in the administration of justice. The top priority for the Diversity and Inclusion 360 Committee was eliminating bias in the justice system. It created short training videos for key players in the justice system: judges, prosecutors, and public defenders. The videos are supported by toolkits that offer assessment tools, web-based resources, an extensive bibliography of the latest research, and a PowerPoint presentation to guide discussions on implicit bias. The training video for judges is a moving and honest presentation that examines implicit bias and what to do about it. It was created with the cooperation of several judges who gave candid assessments of their own implicit biases. So I have to say, unlike what one of the justices said on the video that you just saw, that there are judges who are willing to admit that they do have implicit biases, and it is what makes this video so powerful, and probably one of the reasons why it won a big Telly Award recently out of 13,000 submissions. And so now I am really honored to present Hidden Injustice, Bias on the Bench. While judges are the intended audience, as you'll see, some of the themes are truly universal, and hopefully you will be able to use them as you go along and do your work. So can we show the video, please? The integrity of our justice system is under fire. The common perception is that it is unfair. People of color make up 30% of the population, but account for 60% of those in prison. The numbers simply don't add up. We all know that judges are fair-minded human beings who want to do the right thing. We also know from a multitude of scientific studies that bias is corrupting our justice system. There's even bias on the bench. Although the effect of bias is real, in most cases, it's not intentional. In fact, it's implicit or unconscious. As ABA president, I have made it my #1 priority to bring together experts to help reduce bias and ensure a just system for all Americans. The centerpiece of the effort is training videos and toolkits to increase awareness and promote positive steps we can take to mitigate our implicit biases. I'm pleased to be able to share with you the first in the series of videos. This one's for judges.
Justice is not blind. People begin their judgment even before they start to think about an individual case.
85% of Americans say that they have no biases, but that's not true.
This is not about people being bad. This is about the brain is looking for what goes together.
We have a system that, in fact, does not produce a fair outcome.
The more Afrocentric features a defendant has, the longer the sentence will be.
When we find embarrassing data, are we just going to sweep it under the rug? Or are we going to say, you know what, those are embarrassing facts, but we can do better? Implicit bias is a mental association that we are not aware of that nevertheless influences our actions.
The reason why we call it implicit is because we don't know that our brain is doing it. So our brain is going ahead and making all sorts of conclusions without sending us an announcement.
We're very good at making very quick, snap judgments. We do it all the time. They're judgments about where we are, what we're doing, and where we're going we can make without thinking about. It's part of what makes us smart, but it creates a vulnerability as well.
Implicit bias is about shortcuts. It's about substituting what you think or what you've become accustomed to seeing or believing, and the shortcuts can be a problem.
It sounds crazy that these mental associations might even exist, but there's overwhelming evidence that they do.
I sentenced a guy on a criminal case who was white. From prison, he wrote accusing me of being biased against him. After reviewing my sentencing patterns, I got the epiphany that no, I wasn't biased against white people. I was doing the greater sin. I was biased against my own people.
When I do think about how I'm biased, I think of the fact that, I'm Catholic, and I went through 16 years of Catholic education, and so my moral compass is very straight. And when someone would come in front of me, especially if there was some sense that they too were Catholic, I would expect more of them.
My mother died when I was very young, and I was raised by an African-American woman who I considered my second mother. And in my civil rights private practice, I mostly represented African Americans. So when I took the Harvard Implicit Association test, I was shocked to find out that I had very high implicit biases against African Americans.
Reaction time measures like the well-known IAT, or the Implicit Association test, have given us a mountain of social psychological data that's really stunning.
Every judge really should take the implicit association test. It really is an eye-opener.
You sit in front of a computer, basically, and the computer measures the speed at which you respond to stimuli that's sent on the screen. I know it sounds preposterous, but the best way to measure the strength of mental associations is to actually have you respond to images and stimuli on a computer.
I did what any good lawyer or judge would do. I assumed the test was invalid. So I proceeded to spend hours and hours and hours researching the origin of the implicit association test and all the social scientists who have studied it. And in the matter of about a month of really hard study, I figured out the test was absolutely valid.
I think a reasonable skeptical judge could say, hey, even if a quarter of that stuff is true, if there are techniques that I can adopt that could allow me to do a better job as a judge and be more fair and square, why wouldn't I do those things? So I think there are three sets of things I want judges to think about. First is mindset. It's really important for all of us to be humble. I know it's hard asking judges to be humble about their decisions, but it's paradoxically only by being humble and recognizing that you are deeply fallible that you could actually become more objective.
You've got the people in front of you. You think you've seen that before. You think you know what the answer of this is. So you have to be sitting in humility at all times, wanting to be taught what is true versus thinking you know what is true.
You gotta be humble. You gotta just own it that we are very good machines, but not perfect. The second thing is slow down. It turns out that if we go really fast, really anxious, and especially if we're in high emotional states, really happy or really angry, those emotional states and this kind of need for speed, this urgency, often leads us to break consistently with our implicit stereotypes.
Judges should be most on guard when they're under pressure to decide quickly.
Slow it down. Slow it down. When you're in the midst of your bias, slow down your evaluation.
Judges, for example, in setting bail, barely see litigants. They're there for a few seconds and then they're gone. It's a difficult environment in which to slow down and make judgments. But the price of moving quickly is probably an excess of reliance on implicit bias.
It is, I think, valuable for you to take a moment, breathe, and slow down and be mindfully intentional about your equality. The third point is to be internally motivated to be fair and square. There's great evidence that says you might have this bias, but if you're highly motivated to avoid discriminatory behavior, and that motivation doesn't come from external requirements, i.e., you're not worried about the PC police coming down and hitting you on the head, you're not worried about just bad PR, but you actually just want to be fair and square. That internal motivation to want to be fair and square actually does matter a lot.
We recommend self-examination on a case-by-case basis.
You have to ask yourself, what am I noticing and what am I not acknowledging?
What are you assuming about that litigant that may or may not be true?
And what information do I not have? What is missing?
When judges are not paying attention, then we see an influence of race on what the judges are doing.
If I were a judge, I would just do my personal inventory and I might invite others. Maybe my clerks, maybe people I'm working with over a period of time, maybe other judges to say, hey, when you see this, or if you notice a pattern, I'm gonna be looking for my own patterns, people who make me nervous. You can feel it inside you sometimes. Why am I having this physical response? What is that about when I don't know this person?
Implicit bias is a bit like an emotional reaction, and you can detect that if you see it happening.
That means I'm gonna have to pay very strict attention. I'm gonna double down on applying the law. I'm not gonna go with my gut. So here's the difficult thing about all of us who've been doing anything for a long time. We love our guts.
We all love our guts, especially lawyers. Lawyers really think they can trust their guts. And what I'm telling you is the best evidence suggests your guts aren't nearly as good as you think they are, especially across social categories of difference.
I have people who will say to me, I can tell who a person is from the minute they walk in, and I'm like, okay, fine, so you got a gut. I'm just gonna tell you your gut is contaminated.
Our guts aren't that good, so we have to be careful about subjectivity and discretion.
Being accused of bias is like a knife slicing your skin. The cut may be shallow, but the hurt is deep.
We all have implicit biases, and unless we work hard to counter them, they have the potential of surfacing and affecting the judgments that all of us make.
You have to be open to taking in and learning new information and processing that information and digging deeper, because the challenges of judging and the challenges of allowing justice to occur in front of you can only be accomplished if you're able to look deep inside yourself.
I'm always considering the effect that my implicit biases might have on everything that I do. So I'm constantly running a mental checklist. Could this be due to an implicit bias? Am I relying on a gut instinct, some subjective feeling, some stereotype, some bias that I may have had, or am I looking at it as objectively as humanly possible for me?
I think it's most important with implicit bias to know yourself. And that can be difficult because we're judges and we're supposed to know it all. And now you're being asked to go to back to first grade in a way, in learning these new skills that'll help you to understand your own bias.
It is difficult to admit our flaws, but we have them, and the only way to confront them is doing just that, acknowledging them.
One of the things that strikes me most is that one of the most important messages is that we have to look deep in ourselves and do a self-assessment, and to understand and acknowledge that if we don't look at ourselves and acknowledge the potential to have bias, we can never work through it. And so I hope that this video has been helpful to you, that you will look at our website or at the American Bar Association to find out all of the various things that are available to you, all of the other work that has been done, the resolutions that we have coming before the House in August, which will provide model jury instructions for jurors concerning implicit bias, and other tools that we hope that can be used far into the future to improve, or at least improve the perception of the justice system and to make it more fair for everyone. Thank you very much.
Thank you so much, Madam President. We have about 5 minutes remaining in our session, but before we invite your questions, your comments, none of which will offend us at all. The first session I gave, I was with Joe Madison on Sirius Radio, 0 filters, and believe me, I got it. So none of what you share with us will offend us, will only help us. But before we go there, I just want to acknowledge Judge Buckley is here, and he was one of the judges in California with us. That was one of the panelists. Judge, would you just stand up? We appreciate so very much what you did out there in California. Of course, your chief judge out there, Tani, and Judge Russell, Judge Rivera, thanks so very much for what you did for us in California. I think our next session will be in Little Rock. I know we'll do some things in Ohio. So we'll move around the country and we'll try to listen to regular folk to tell us how we can improve our court system. To your right is Tina. Raise your hand up front. And all the way in the back is Patty Tobias. And so what we want to do is give you an opportunity to hopefully make comments as opposed to ask us questions, because the whole idea is for us to be on a listening tour to hear what you believe would be beneficial for judges to hear, the things that you think that we ought to be doing that will improve our nation's state court systems. So I'm certainly going to invite your comments. Be kind to us. I see one way in the back. Thank you so very much.
Hello. Thank you. My name is Keir Bradford Gray, and I'm actually a chief public defender, and I came here really just trying to learn more as to how do I integrate what I do to what the court managers are trying to do when achieving access to justice. And one of the things that I don't hear a lot is when we all are working in these systems and we're trying to promote the same thing that you're discussing, which is fairness, we don't invite each other to the table to discuss what is our role. So judges making decisions and trying to get rid of the bias, it would be incumbent upon defense counsels or defense systems to do more humanizing and to do more to bring forth information that would be useful and helpful. In Pennsylvania right now, we have risk assessment tools that have nothing to do with who the human is, but everything to do with what is listed on a person's record or listed in some kind of information gathering state without other things. And so how do we connect more with defense lawyers who run systems for indigent defense communities to put more burden on us and help us understand what will help you, meaning you judges?
Well, thank you. I'm not sure I understand the question fully. I'm not sure that I understand how to respond, other than to say that we judges understand that we have to be better listeners. You heard on just the last one of the last statements on the ABA tape. We don't know it all, and we have to depend on the lawyers. We depend on court personnel. My assessment of lawyers, for example, my assessment of lawyers comes not from my evaluation of the lawyer on the initial meeting between myself and the lawyer. My assessment of the lawyer usually comes when my clerk or my court reporter, the court manager, comes back in my chambers and says, "Judge, we got an idiot outside." So, I mean, I understand what you're saying. We certainly need to be better listeners. I think the judges have to have an open door policy. We all don't have that. We have to have an open door policy, willing to listen to the public defenders. In California, we dealt with this issue. We dealt with the fact that public defenders are not paid enough money, that they don't have enough resources, and consequently, that results in not having adequate counsel. But I hear your concern. We'll make sure that we start to try to address it. Thank you so very much for your question and for your comment. Others, please. Where's my California contingency? I know they were here. Oh, there they are. Thank you.
Good afternoon. Thank you so much for this presentation. My name is Elisa Chingary. I am an attorney. I have served as a court administrator for many years. I am now the elected clerk of Superior Court in Charlotte, North Carolina. Our courts have been talking about race, implicit bias, and its impact on decision-making for more than a decade. And we have done that not only among our judiciary, but invited law enforcement and educators in the Department of Social Services to join this conversation. It has been at a very high level of leadership. It's a body of work that I am very proud of. My question is this: Where we have, I won't say failed, but yet to achieve, is to take this conversation out into the community and talk to those that are most vulnerable at being hurt and harmed by our system decisions. Do you have advice for me for taking this high-level conversation around organizational development to the community?
I have a question first. And are prosecutors involved and police involved in what you're doing?
Absolutely.
Okay, so I think that, you know, one of the means that you can attract people generally are through churches. And so I think that when the community has to know that you're not coming to them in any kind of threatening way. And I think churches are generally the safest places to do that. And I think that the conversation, I think that everybody has to talk amongst themselves first before they go to the community, to understand that things like Judge Edwards said, that he could take anything, he can take any kind of abuse. He didn't really say that, but the people who are going out to speak to the community, so many times when we go out, we are defensive and not really receptive to what the community has to say to us. And so, you know, and so people generally point fingers at prosecutors and judges in particular. And I think that when you go out to the community, you have to be ready for that, and be receptive to that and not be defensive and try to explain in objective terms, because the people who are in the audience, they come with their own biases too. And maybe you need a separate facilitator to facilitate the discussion between the two of you.
And I want to follow up. Are there, I know Judge Buckley is here. Are there other judges in the room? Would you be kind enough to stand up, all the judges? Terrific, terrific, wonderful. Have a seat. You know, this judge thing works. Have a seat, please, thank you. You know, this judge things work. I got tired of sending black kids to jail. I was the chief juvenile court judge in the city of St. Louis for 8 years. I got tired of sending black kids to jail, so I wanted to do something different. So I decided that crazy zero tolerance law didn't make any sense. Zero tolerance in my mind always made zero sense. So what I wanted to do was something different. So I opened a school. And so all the kids that had type 1 violations, 300, 400, 500 of them, they come to my school. But I entered into these wonderful partnerships, a lot of partnerships, about 25 partnerships. So I started to send letters out. I sent a letter out to the police chief and I said, hey, can you come and meet with me about crime in our city? And the police chief showed up. I said, man, that's pretty good. Then I sent a letter to the mayor and the mayor showed up. Then I sent a letter to our congressman and the congressman showed up. Then I sent a letter to Senator Blunt, a Republican in the state of Missouri, and a letter to Senator Claire McCaskill in the state of Missouri, and they showed up. I said, damn, this judge thing works. And so judges have to take the leadership on some of these issues. The judges have to be willing to step out, come off the bench, like what we're doing now. I know that we prefer to stay in our chambers. We prefer to write our orders, and then we send them out with our public information person, and we expect everybody to comply. That's how we've always done it. I think that we have to do a new thing now. We have to be willing to say we have to have fairness across all levels in our system. I understand that there are responsibilities that the executive officer in your respective state has, and that the legislative bodies are different. I understand sixth grade civics, separation of all of these branches of government, but I think judges have to stand up. So that will be the last thing that I'll say to my colleagues. We have to stand up and we have to be leaders in this issue of implicit bias. In our courthouses, we have to check it. In our prosecutor's office, We have to check it when there's ineffective assistance of counsel at the defense level. We have to check it when police officers come in and they don't have the appropriate probable cause. We need to say something, and we need to take leadership on these issues. Thank you all very much for listening to us this afternoon.